Hey everybody, it's Christy Miley with Caldwell Banker Shook and Redbird Realty Group, and I wanted to go over today some of the standard contingencies that are in our purchase agreements that are built to protect buyers. And as long as you haven't waived those and you're working with a licensed realtor in the area, you should be using the contract that I'm referencing. It's an Indiana State and Lafayette Board of Realtors purchase agreement. So just want to mention that as long as you're working with a licensed realtor and you're using the contract that I'm referencing, these should be in there to protect you. So moving just in a chronological order, the first contingency is the contingency for the property to appraise at no less than the agreed upon purchase price. So once you get an accepted offer on a property, you will pay for and order an appraisal, and it will be provided directly to you by the lender once it arrives, and it's a multi-page report that shows you the sales in the area, and it either passes or fails your property that you're pursuing at the price that you have offered. So that is some level of protection from overpaying for a property. You will have an independent appraiser reaffirming if the bank agrees that they would like to put their portion of the money in at this rate. And we can always talk about these more as well, and how they pertain to your particular deal. And then it goes down through the mortgage contingency. So when you are issued a pre-approval, if you're working with a quality mortgage originator, they should have asked you the proper questions to determine your true approval status. But that is not infallible. I have had people that have been issued a pre-approval, especially on my listings. This doesn't happen commonly with my buyers, but I have pended listings before with buyers that had what seemed to be totally legitimate pre-approvals, and then later we found out that unfortunately upon the interview by the originator, they didn't know to ask the right questions, and something popped up towards the end usually that actually did disqualify them from being able to obtain the mortgage that they thought that they could receive. So you have a mortgage contingency written into your agreement that if you were to lose the ability to be approved after you've already had an accepted offer, you should be able to use your mortgage contingency to be released legally if you truly legally did lose your ability to be approved after writing your offer. And these are just very basic explanations of these concepts because I'm trying to keep this video short. So this is no replacement for having an actual conversation with me or your agent of choice. These are just a few quick tips to let you know, if you aren't aware, what types of contingencies are built into agreements unless you waive them. And so and then it moves down into a homeowner's insurance contingency. So the offers are always contingent upon your ability to secure homeowner's insurance. And when you do pull your insurance quotes, it is somewhat like Carfax for a home, in the sense that you are hoping, if there have been recent or large claims of note, that when you get your quotes, they will be revealing those to you. So for instance, if there was a fire 3 years ago in the property, it doesn't necessarily mean that that's a problem, but it's something you would like to be aware of and then be able to look further into that. And so just a note, you do have an insurance contingency. And then the big one that people are typically aware of but not completely sure how the verbiage reads is, of course, the inspection contingency. So this season, and this is being filmed February of 2021, the last year I've seen a lot of inspections waived because we have had such a competitive market, and we've had a lot of investor interest, and a lot of investors might be a little more inclined to do all cash, no appraisal, no inspection. We've had a lot of these standard contingencies being waived. I almost never work with a buyer that waives an inspection. I myself have purchased property and I have waived the inspection. So, I mean, it happens and it's a personal choice, of course, but in general, you will always have an inspection contingency written in. And so the way that the verbiage reads, and this is just a recap, is if upon inspection a major defect is uncovered in the property and you ask the seller to correct it and then they deny it, then you have arguably, although I'm not an attorney, legal grounds to initiate a termination. And so that is how the inspection contingency reads. You get a certain amount of days to do your inspection and then reply in writing to the seller with any repair requests, and then they get a certain amount of days to answer you back. And if they deny a major defect, then we can pursue termination if you'd like. You don't have to, though. And so the biggest question, of course, is what is a major defect? So I'll just go ahead and read it line by line, but then when we talk, we will want to interpret these because some of them can fall under a gray area, but the actual verbiage in the agreement is that under Indiana law, a defect means any condition that would have a significant adverse effect on the value of the home, anything that could significantly impair the health or safety of an occupant, or something that if not repaired, removed, or replaced could significantly shorten or adversely affect the anticipated life of the home. So this is why it has to be a conversation, because words like significantly adversely affect can become a gray area. And then you also have a contingency for the ability to secure title insurance, which that's on the seller side typically. And you can write in contingencies for the right to review the Homeowners Association information. You can write in contingencies for use limitations, although my personal thoughts are that's a pretty rare occurrence that you wouldn't know what your intended use is and if the property qualifies for it. So if it's a residential property zoned residential and you're using it for residential, I don't see a whole lot of use limitations being written in as contingencies. People typically do their homework in advance of even writing the offer. And there are other things you can write in, of course, but those are the main contingencies that I like people to know. The offer is contingent upon appraisal, so it does need to pass for the value that you offered, and an independent party will be assessing that for us. It's contingent upon your ability to get the loan that you were told that you could get. It's contingent upon inspection, insurance, and anything else that we have written in. So I hope that helps a little bit. Again, these videos that I do are just kind of on the fly, relatively informal. I'm just trying to get some basic information out there, but they won't be able to replace a quality agent going over every individual detail as it pertains to your situation and your offer. So if you need anything, please let me know. It is ChristyMiley.com or RedbirdRealtyGroup.com, and my number is 765-427-1905. Thank you.